So this happened Thursday. A federal judge issued an arrest warrant for a sitting president. Last night, an emergency appeal was filed. This morning, the Supreme Court intervened. That is all it took, 48 hours. According to court filings made public at 6:47 a.m., Chief Justice John Roberts issued an administrative stay of the arrest warrant pending a full Supreme Court review. The 142-page emergency appeal documents have just dropped, and I have been going through every single page. You saw the headlines. Now here is what they missed. Trump's legal team filed directly with the Supreme Court at 11:23 p.m. Thursday night. Roberts acted within 7 hours. That marks the fastest emergency intervention in modern Supreme Court history involving a president. Let me be very clear. This is not a final ruling. It is a pause. But that pause changes everything that was supposed to happen today. Let's set the stage with some quick context. Donald Trump, the 47th president, has been under a federal arrest warrant since Thursday morning. The core issue is whether a sitting president can be arrested under a federal warrant while in office and whether the Supreme Court will intervene to stop it. Here is the fast timeline. Thursday at 10:47 a.m., District Judge Richard Holloway issues the arrest warrant based on alleged perjury evidence. Thursday at 11:47 a.m., the White House files an emergency appeal to the D.C. Circuit. Thursday at 11:23 p.m., Trump's attorneys bypass the circuit court entirely and file an emergency application directly with the Supreme Court. Then Friday at 6:47 a.m., Chief Justice Roberts issues the administrative stay. That is the setup. The emergency application to the Supreme Court argues that this is a constitutional crisis requiring immediate intervention. The stay means U.S. Marshals cannot execute the warrant while the court considers the case. Trump's team went over everyone's head, straight to the highest court, and Roberts said yes to the temporary pause. The question now is, what happens next? Now let's get into the evidence. The first document filed Friday morning is where I want to start. I pulled page 8 of Roberts' order. It says, and I am quoting directly here, upon consideration of the application for stay and the response thereto, the execution of the arrest warrant issued July 23, 2026 is hereby stayed pending further order of this court. That is not my interpretation. Those are the words of the Chief Justice. What it means is that the warrant still physically exists, but it cannot be enforced while the Supreme Court reviews the constitutional questions. But here's what really got my attention. On page 3 of Trump's emergency application, in a completely different section, the legal team argues that no court has ever authorized the arrest of a sitting president, and that the separation of powers implications are so grave that only this court can resolve them. When you put those two pieces together, it is clear that Roberts agreed there is a serious enough question here to hit pause. I went through the application twice, and the pattern is clear. Trump's argument rests on 3 distinct pillars: presidential immunity from criminal process while in office, a separation of powers violation if the judiciary can arrest the executive, and the lack of any constitutional mechanism for arresting a sitting president. All of this is documented in the 142-page filing. Now let's look at what nobody else is covering. Page 67 contains the government's response, filed at 4:12 a.m. this morning, just 2 hours before Roberts' decision. The Solicitor General argues that presidential immunity does not extend to criminal conduct undertaken in a personal capacity, stating definitively that perjury is not an official act. Read that sentence again, because that is the core divide in this entire crisis. The defense says any act during the presidency is official, including testimony about prior conduct. The prosecution says lying under oath is personal criminal conduct, not a presidential duty. The government's brief cites the monumental case of United States versus Nixon from 1974, which forced Nixon to turn over the Watergate tapes. A quote from page 73 of the government filing reads, "This court unanimously held that not even the president is above the law. That principle applies with equal force here." But Trump's team anticipated this exact argument. On page 89 of their application, they distinguished the Nixon case by pointing out that the matter involved document production, not a physical arrest, and that the constitutional difference is enormous in magnitude. Roberts writes on page 9, "This matter presents questions of exceptional gravity concerning the separation of powers and the functioning of our constitutional system." That specific language, exceptional gravity, appears in Supreme Court orders only when the court believes it must intervene immediately. This is the first time a Chief Justice has ever stayed an arrest warrant for a sitting president. The U.S. Marshals stood down effective 6:47 a.m. Roberts has the authority to issue administrative stays on his own, but page 11 indicates he will refer this matter to the full court at the earliest practicable time. If this breakdown is useful, make sure to subscribe because this story is moving hour by hour, and I will be covering every Supreme Court filing, every response, and every development as the highest court in the land decides this unprecedented question. But look, I have to be fair here. The other side has a few points actually. Legal scholars who support the arrest warrant argue this is about basic accountability, not politics. And honestly, some of it holds up logically. Their argument is structured in three parts. First, no one is above the law. If a president can commit perjury without consequence while in office, it effectively creates a lawless executive branch. Second, the warrant is based purely on evidence. A federal judge reviewed 14 audio recordings and found probable cause. Third, they argue that impeachment is not enough because Congress cannot address criminal conduct with the same punitive mechanisms as the courts. Lawrence Tribe, a constitutional law professor at Harvard, put it this way in a statement this morning: Roberts's stay is procedural, not substantive. The court must still rule on the merits. I do not agree with all of it, but that is definitely not a trivial statement. What they have on their side is precedent. United States versus Nixon established that presidents are not above the law, and Clinton versus Jones established that civil suits can proceed against sitting presidents. Even Neil Katyal, the former acting Solicitor General, who has been critical of Trump prosecutions in other contexts, admitted in a Washington Post op-ed published at 8 a.m. that the separation of powers works both ways, and the judiciary must be able to check executive criminality. I am not here to tell you who is right and who is wrong. The defense interpretation is that arresting a president destroys the separation of powers and makes the executive subordinate to the judiciary. The prosecution interpretation is that immunity from arrest makes presidents effectively above the law. What makes this so viscerally complicated is that both of those statements can be true at the same time. The Constitution provides impeachment as the remedy for presidential misconduct, and the founders explicitly debated whether presidents could be prosecuted while in office, leaving the final text ambiguous. However, the defense raises valid concerns about the precedent of what happens if every future president faces arrest warrants from politically opposed judges. How can a president function if they are subject to criminal process during their term? Professor Jonathan Turley, a constitutional law expert at George Washington University, wrote at 7:30 a.m. that Roberts had no choice and that this question is simply too big for any single judge. That is real analysis. Former Attorney General Pam Bondi, in a Fox News appearance at 8:15 a.m., argued that impeachment exists for exactly this reason: to allow the Congress to handle presidential accountability. What I can tell you is what the documents show. They show that Chief Justice Roberts believed the constitutional questions are serious enough to stop this process cold until the full Supreme Court weighs in. This did not come out of nowhere. Here is a quick backstory. 3 months ago, Trump provided sworn deposition testimony in the documents case. 6 weeks ago, federal investigators obtained audio recordings that allegedly contradict that testimony. 3 days ago, prosecutors filed an emergency motion with those recordings. Yesterday, the warrant was issued at 10:47 a.m. Former White House counsel Ty Cobb predicted weeks ago that if they have him on tape contradicting sworn testimony, this goes to the Supreme Court instantly. What happened next was exactly that pattern. In every presidential legal crisis, the endgame happens at the Supreme Court. Watergate ended at the Supreme Court with the tapes ruling. The Clinton impeachment involved a Supreme Court precedent on civil suits. Every single time, the constitutional questions are too big for lower courts. The difference now is that this is not about documents or civil suits. This is about whether a sitting president can be physically arrested. No Supreme Court precedent directly answers that question. Nixon resigned before facing potential criminal charges. Clinton faced civil suits, not a criminal arrest. No president in American history has been under an active arrest warrant while in office. Roberts' decision to stay the warrant strongly suggests he knows the court needs to answer this definitively, because whatever they decide becomes the unbreakable rule for every future president. Let's zero in on Friday at 6:47 a.m. Eastern Time. Chief Justice Roberts issued the stay from his chambers. There were no oral arguments and no full court conference. The order explicitly states an administrative stay is granted pending further consideration by the court. What followed was a cascade of activity. Stay notification was sent to all parties by 6:52 a.m. The U.S. Marshals Service issued a stand-down order at 6:58 a.m. The White House was notified by 7:03 a.m. That process took just 16 minutes. Now, here is what everyone missed while they were focusing on the stay itself. The Solicitor General's brief, filed just hours earlier, contained a bombshell. Page 81 reveals that prosecutors offered Trump's team a deal on Wednesday, called a proffer. The deal was simple. Acknowledge the recordings exist, stipulate to the factual inaccuracies in the deposition, accept a contempt of court sanction, and avoid criminal perjury charges entirely. Trump's response, according to the filing, was an absolute rejection within 90 minutes. The White House counsel's response this morning was an immediate statement at 7:34 a.m. calling the stay a vindication. This was not reactive. It was meticulously coordinated. You can see it in the messaging, where 3 different Trump attorneys gave nearly identical quotes to different networks within minutes of each other. This is where the procedural analysis gets really interesting. The language of the stay order matters enormously for what comes next. Roberts wrote, "pending further consideration," not "pending full briefing and argument." That phrasing leaves the door open for the court to either fast-track this for emergency arguments next week or request full briefing over several weeks. Legal analysts are currently parsing every word of that sentence. If the court moves fast, we could have a final decision within days. If they want full briefing, this constitutional limbo could take weeks. Meanwhile, the warrant still exists, but it cannot be executed. This is a constitutional crisis in slow motion. What I am about to show you next about the Supreme Court's likely next steps changes the entire way we should think about this situation. What are the experts saying? A former Supreme Court clerk to Justice Scalia with 12 years of appellate experience analyzed the language and said Roberts' signal views this as extraordinarily serious, but not necessarily favoring either side on the merits. In plain English, the stay does not tell us how the court will ultimately rule. It just tells us that they are taking over the process. Professor Michael McConnell, a Stanford constitutional law professor and former federal appellate judge, added that the court will likely expedite this, but they will not rush to judgment on questions this fundamental. The key takeaway there is that fast does not mean hasty. Even Erwin Chemerinsky, the dean of Berkeley Law and a frequent critic of expansive presidential power, admitted that Roberts was right to stay the warrant, stating simply that the court must resolve this. When constitutional scholars across the entire political spectrum agree that the court should intervene, you need to pay attention. Former Acting Solicitor General Neil Katyal broke down the likely timeline, explaining that he expects the court to request supplemental briefing by Monday, schedule arguments for next week, and rule by the end of the month. Lisa Blatt, one of the Supreme Court's most successful advocates with over 40 arguments under her belt, raised the stakes even higher, noting that Roberts knows this is Bush versus Gore-level stakes and that he will want unanimity if it is humanly possible. That last point matters enormously because a 5-4 decision either way looks purely political, while a unanimous ruling carries immense institutional weight. The consensus among Supreme Court practitioners is that the court will expedite the process, oral arguments are likely given the stakes, and the ruling will try to establish a clear precedent for all future cases. What is remarkable is that even the experts who violently disagree about the outcome agree on the process, because the next time a president is accused of criminal conduct, this is the case that courts will cite. Now, why should you care? Let's have some real talk about how this affects actual people. If you are an American citizen, this single ruling will define the parameters of presidential power for generations. The Supreme Court is about to answer the ultimate question: can the president be arrested while in office? Your government is about to establish a precedent that lasts forever. This is not an exaggeration or being dramatic. This is literally the foundation of how the American government works. The next time you cast a vote for president, the powers and limits of that office are being defined right now in real time. If the court says presidents cannot be arrested while in office, future presidents could theoretically commit crimes knowing they are absolutely immune until they leave office. If the court says presidents can be arrested, future presidents face the existential risk of politically motivated prosecutions from opposed judges. That is the impossible dilemma every single justice is wrestling with at this very moment. You have three co-equal branches of government in direct conflict. The executive says you cannot arrest the president. The judiciary says no one is above the law. The legislative branch is watching carefully to see if their impeachment power becomes meaningless. If Trump spends the next several weeks or months under the cloud of an enforceable arrest warrant, how exactly does he govern the country effectively? If you depend on the federal government, Social Security, Medicare, if you are a federal employee or a military family, presidential dysfunction directly impacts your daily life. Whatever the court decides becomes the unbreakable rule of law. If they rule presidents can be arrested, every future president faces that risk from political opponents. If they rule presidents cannot be arrested, future presidents have absolute immunity from criminal process for 4 to 8 years. The financial markets reflect this anxiety. Markets dropped 234 points on Thursday on the news of the warrant and recovered 178 points this morning on the news of the stay. If you have retirement savings, investments, or any economic exposure, a constitutional crisis creates severe volatility in your portfolio. The Supreme Court's legitimacy itself is on the line. After the Dobbs decision overturning Roe, public trust in the court is at a historic low. How they handle this case directly affects whether Americans believe the court is operating above the fray of politics. Understanding what the court actually decides versus how the media characterizes the decision is how citizens evaluate massive constitutional questions. It is about information, not panic. How did President Trump respond? We saw immediate vindication messaging. Within 43 minutes of the stay order, Trump posted on Truth Social calling it a total exoneration by the Chief Justice, claiming corrupt judges tried an illegal arrest and the Supreme Court stopped it. The immediate reaction from legal analysts is that this characterization is factually wrong. The stay is not exoneration, it is a procedural pause. Roberts did not rule on the merits of the perjury allegations, only that the court needs to decide the constitutional question. The White House then issued a formal statement at 8:12 a.m. stating that the Supreme Court has rightfully recognized that this unprecedented action requires the highest court's review. Then Trump's attorney, John Lauro, in a CNN interview at 9 a.m., pushed the narrative further, stating that this stay proves what we've said all along. Arresting a sitting president is constitutionally untenable. The prosecutor's response came at 9:47 a.m. through a Justice Department spokesperson who stated calmly that they respect the Supreme Court's process, but that the evidence remains strong. Then, in the latest development at 10:23 a.m., Trump announced he is returning to Washington from Bedminster, calling the stay a complete victory. He is not cooling down. He is escalating the rhetoric, even though legal experts continuously note that the stay says absolutely nothing about the strength of the evidence or the ultimate outcome. What remains unclear at this hour? First, we do not know whether the full court will hear live oral arguments or decide the case on the briefs alone. Second, we do not know how quickly Roberts will convene the full court to address this procedural schedule. The Supreme Court's next scheduled conference is Monday, July 27th at 9:30 a.m. That is the moment when the 9 justices can privately decide the scheduling for this historic case. Trump's legal team is reportedly already preparing for potential oral arguments as soon as Wednesday or Thursday of next week. The date to watch is Monday, July 27th. By the end of that conference, we will know whether this gets expedited arguments or a slower, more deliberate briefing schedule. If arguments are scheduled, they will likely fall in the window of July 27th to the 31st. Also unclear is the vote breakdown on Roberts' initial stay. Did he issue it completely alone on his authority as Chief Justice, or did he consult the other 8 justices informally? Legal observers are closely watching to see if any individual justice files a statement agreeing or disagreeing with the issuance of the stay. Make sure you subscribe, because I will break down Monday's Supreme Court conference decision the moment it is announced, and I will cover oral arguments live if they are scheduled. Hit the notification bell so you do not miss a second of this. Here is exactly where we are right now. The arrest warrant for President Trump has been stayed by Chief Justice Roberts as of 6:47 a.m. The Supreme Court will consider the constitutional questions at the Monday conference. The U.S. Marshals cannot execute the warrant during this stay period. The upcoming schedule is critical. Monday, July 27th at 9:30 a.m. marks the Supreme Court conference to determine case scheduling. Potential dates for oral arguments fall between July 29th and 31st if the process is expedited. The original deadline for various other Trump case filings are now likely delayed in light of this constitutional crisis. The congressional response continues to ramp up, with the House Judiciary Committee announcing hearings on presidential immunity scheduled for next week. And critically, the 14 audio recordings that sparked this entire national crisis remain under seal, hidden from the public view. The clock is now running differently. It is no longer about the immediate execution of a warrant. It is about the deliberate process of the Supreme Court. Between now and Monday's conference, the entire legal world is holding its breath and preparing for arguments that could fundamentally reshape the American presidency. That is the state of play. The president is stayed, but the nation is waiting.